with clear guidance in terms of how we are going to proceed this afternoon. I believe that we are ready now to engage. Honorable members, let us start alphabetically. Those countries that may not be in the room or who have joined us should also be able to join in and make their presentation. So do we have interpreters online? We're all fine? Okay. Let me start with Angola. Honorable members online, if they're there, may we have Angola? We may have to put on our microphone. If it's not English on the floor, we wear these so that we are able to hear interpretation. Is Angola present online?
Yes. Yes.
Yes. Thank you very much. May we have Angola make their presentation. Thank you, Honorable Nascimento.
Muito obrigado por me ter dado a palavra. Angola
Thank you very much for giving me the floor. Angola does not have a presentation as such, but we agree with what has been discussed up to now. And now let's proceed and we will see what we'll discuss next. But for now, we do not have a presentation because from Angola, we only have one person. Therefore, we couldn't discuss it as a group. And my personal opinion is that whatever was discussed and is in this model law, we do agree because it does not bind any country. It is a guiding document. We do not have anything against to what has been discussed. I believe that we are now at page 56, is it right? 52, I mean. I think in the English version is page 53. 53.
Okay, thank you.
Thank you very much. So I'll hand over to the drafter to take us through where we stopped. The instruction is that we go page by page, alphabetically for all the countries. If they have a comment, they'll make a comment. If there's no comment, we move on to the next page. That is how we're going to proceed. I started with Angola, but let us not use page numbers because it's different in different languages. Why don't we start at the heading? Yes.
Okay. Thank you very much, honorable members. Clause 3, conflict and review of national laws. That's on page 53. Oh, sorry, but I'm just trying to point out it's conflict and review of national laws.
61 da página da...
Angola said they're fine. Botswana? Democratic Republic of Congo?
Botswana, can we?
Botswana, yes, go ahead, Botswana.
Oh, thank you, Madam Chair. In Botswana, we don't have anything to say.
Thank you, Botswana. DRC?
DRC?
Yeah. Sorry. we in DRC, we try to have our comment in global instead of going page by page. I don't know if, what do you think about that? That's the way we understood how we can do things actually.
Thank you. I stand guided by the House. I put the question, do we go page by page or we allow countries to give presentations on the whole model law? There was guidance given for as long as the content, when you do globally, we can refer to the particular section in the model law to facilitate the drafters. That would be helpful, but I need guidance. What is prepared? Because earlier the guidance.
But we settled for global.
Those who say global.
We went global.
Global. Okay, there's consensus. Thank you very much on that. So I believe Angola has indicated their view, unless Angola wants to come back for clarity, but I think it was quite clear. Angola said they've not met, and their position is that what you have already had. Botswana, what is your position? Not on the particular page. Is that okay, Madam Drafter?
Yes, SG, as long as they point out the particular clause where they wish to amend, there's no problem.
Okay.
Yeah.
All right. I think that is understood. It's in order. Hold on. No, Malawi had their hand up.
Yes,
this side.
Madam.
Was it Malawi? Yes.
Yes, Madam Chair, we go up to which page or which section, please?
The guidance, Honorable Esperance, is that we allow leaders of delegation to give commentary on the whole model law because they've consulted, they've read it.
This is what we agreed before.
They will point the drafter. We're all taking a record. And also if you can submit, it will also be good if you submit your input. So I'll start alphabetically unless I'm guided otherwise. We proceed accordingly. Yes, so Angola said they are fine. Their comments are what it is. Botswana, was that in reference to the whole document? Or was it just to the page? Honorable State?
No, we are just okay in all pages.
On all the pages?
Yeah.
Thank you. May I now move to the Democratic Republic of Congo?
Okay. Attends, je lis. Can I proceed? Okay. C'est en français. I'm going to make it very easy for everybody because our comment is in French. So please allow me to read in French. Thank you. La loi type.
The model law against
BG,
violence against women had the objective to aid the member states of the SADC to reform and to review and to modernize their national laws. Okay?
Second bullet.
Second bullet.
Ce projet de loi type
this draft model law should have simply presented the main principles as benchmark tools for the member states to draw up their national legislation. Thus, the model law should avoid various details in respect of certain concepts. 4, the brief analysis should not take into account any inadequacy with national laws. Consequently, in consequence of which, we suggest that the words
son adaptation.
Words that would render its adaptation easy should be drawn to cut off from the text.
Apologies, we have to repeat that. I don't think I got it.
Okay, shall I repeat?
Yes, please.
En conséquence,
In consequence of which,
recommandé
it is highly recommended to withdraw from the text the terms which are divisive. This would make it easier to adapt and to adopt the text.
Did we get interpreter? You are soloing some words.
I think it's it's adoption.
Yeah.
Okay, it's adoption. I think he meant both.
Shall I?
No, it's not you, Honorable Tim.
Oh, he's
I think
interpreting.
the interpreter.
Sorry.
Je crois que l'interprète a déjà.
The interpreter say, I pick up, it is highly recommended to withdraw, but I don't understand the context and which section should be withdrawn. Is it just a general comment?
No, it's which regard the fourth, I think, the fourth bullet. Or maybe the third, no, the bullet before, when we said ainsi, la loi type devait
Thus, the
éviter
model law should hesitate, should avoid certain details in respect of certain concepts. The last point.
Are we together, drafter? Do you understand the concepts, or are we referring to that paragraph?
Yes, we are referring to that paragraph in yellow, exactly.
Okay. So let's just say, if we say concepts, there are many concepts in the model law. So maybe to say in section so and so, we recommend to amend as follows: delete, then we can follow, or replace so that we are able to follow.
Yeah.
Thank you.
Não tem tradução.
That's fine.
We can continue.
Yeah, let me just reread the last point. Again, we are referring to the third section in the yellow. So I read, quotes, en conséquence, il est recommandé
Frequently, it is recommended to delete in the text the terms which divide us, and this would make its adoption easy. That's exactly what he said.
Thank you.
Merci.
Thank you very much. No, DRC is saying, given this particular section 3, they recommend that we delete what divides the house, that we must rather keep to making sure that the model law is not affected simply by what divides us. So they're recommending deletion of those populations that are mentioned there. No, it's consequential in the entire document. That is what the drafter has been trying to explain, that for her purposes of her going back to reconstruct, she has highlighted, consider that as a deletion. Yes, and I think we missed that in the morning. She said, consider that as a deletion because I'm keeping it in yellow so that I may be able to go back and find a replacement of how we can be able to modify that particular text. So I think if we go on that spirit, we'll be able to find each other because that is what she was trying to explain from morning. So I think the point of the DRC has been taken. Is there any other Honorable Tumba? Is that where we end with submission from DRC? You may proceed, sir.
Can I?
Hello?
Can I?
Yes, proceed. Continue.
Yeah. And the reason being because that will also help us in the rest of the text.
No, we've had DRC just finish. It's okay.
No, I did indeed.
Oh, Stephanie.
Yeah, Stephanie.
Oh, okay. Merci beaucoup. Okay, it's fine.
Thank
That's
you very much. Fine. Tell
you been able to follow? Yes, thank you. Shall we now move to the next country? What is the alphabet? We now move to Eswatini.
Thank you very much, Madam Chair. We've met as delegates to this conference and have agreed that in general terms, the document is acceptable and we're comfortable with it, except of course, certain areas needs clarification. We can only clarify or seek clarification as and when we get into that paragraph, into that chapter, as it were. But in general terms, we are happy, except, and I repeat, except the contentious, I will say contentious because it's been holding us throughout this meeting. That is paragraph 1.2.11. We want to follow, or shall I say, want to align ourselves with the definition, with that caption there, up to UN definition, with the word added, without discrimination. Anything else, especially that one that is in brackets, we discard. Similarly, in under part 1 preliminary provisions, domestication of the law, no problem there. But under application and scope, which is 2.3, as it is on the board, we would appreciate if that sentence or that text there ended with violence against or between categories without discrimination, and not write those names there were so. Please. But otherwise, we accept the document on the principle that it is non-prescriptive and it is persuasive. But within the whole model law, there are areas which seem to go against the spirit of non-prescription, like the use of the word shall, which we touched. If we just amend that, we should be happy. Otherwise, we know the model law, it has helped us in a lot of areas back home. So it should help us with what I've just said. I thank you, Madam Chair.
Thank you very much. Eswatini. The next country, shall I proceed? Because I see you are drafting as we go along.
I'm waiting for the countries.
For the next country.
Yeah, because
okay.
I just finished with
Eswatini.
Eswatini, yeah.
Okay, no, thank you. All right, the next country now is Lesotho.
Thank you, Madam SG. I'm not sure how we are to proceed because I think the last decision was that we take the entire document. So I actually had some notes page by page. So should I just go throughout the document or we're still getting general comments first?
No, my understanding is that countries are exhaustive as they present. So have the floor and really just go from the beginning of the model law up to the end as per your delegation submission.
Okay, thank you, Madam SG. We'll start right from the top with, we're on part 1, 2.1, which is the very application and scope. So we feel that there should be an inclusion there on 1 of economic status and physical appearance. That's 2.1. Then we move down to page 3, to 3. That is still on application and scope. 1, 2, 3. Well, then we move to 3, conflict and review of national laws. 3 of it, it reads, where there are conflicts and inconsistencies between gender-based violence laws with laws relating to family and divorce, property, housing, social security and employment, the gender-based violence laws shall prevail, and the legal framework that promotes, we wish to remove the word women's. It's selective, and we just leave that promotes human rights and gender equality, and the elimination of violence against women shall apply. Then we move to 4 of it, which is extraterritorial jurisdiction of national laws. There is question for clarity there. 4.2b. It reads, by a stateless person who has his or her habitual residence in a member state. Now, normally when reading law, we use his. It's not normally the case that we apply his or hers. So this is just for clarity, whether it's proper or we would use another, is it pronoun? That's for clarity there. And we move.
Are we together? Madam Drafter, we shall, yeah, it's okay. I know. We are, I'm stuck, honorable members.
So moving.
Because we are developing a gender-based violence model law. We are trying to be gender neutral. At the same time, we're taking away and replacing. Evidence shows us that the majority of people who are highly affected by this gender-based violence is women. So without getting into the detail, I'm wondering how we can really balance responding to, I don't know, Madam Drafter.
Madam,
we seek guidance.
What the honorable members should note is that the whole document is now gender neutral, and we are using gender neutral language. Okay, if in certain places we just draft in the neutral, in the third person, other places where we feel it's necessary, we use his or her, or we repeat stateless person, for example. So it's perfectly in order to use his or her. Many other countries are now adopting this form of drafting style. I know South Africa definitely uses this drafting style. There's nothing wrong with it because it's gender neutral. It applies to all persons. And then I don't know how we are going to proceed in this manner. It will take maybe even a little longer, but we shall abide by it. But gender neutral language, I think, is important. Okay. There are certain instances where, and I said it in the beginning, there are special provisions relating to women, directly women, as a marginalized groups that are severely affected by GBV, and you shall see them. If you don't note them, I can always point them out to you. We even state special provisions shall be made of. Okay. And we proceed in that way.
I'm sorry to interrupt. I just want us to do a balancing act to make sure that the substance of what it is not affected. So the drafting should be left to the drafter, because it is very easy for us to have commentary, but she may go back and find that the discourse does not reconcile with proper drafting. But the principle we can take and highlight in our notes without quickly, because we can make mistakes as well in the process. I hope I'm understood. Yeah. There are elements of just for drafting that we should not occupy, but I hear you. The principle is taken. But we're also hearing that this is modern drafting does accommodate that. So I believe, yeah. So we don't necessarily draft. I was intervening so that you don't necessarily delete, even if you know, because it will be very sad for us to meet later and realize, why did we allow this to happen? Yeah, so we should create a balancing act.
Thank you, Madam SG. Yes, actually, we also stand to be guided in the process. I move to 7, protection from discrimination. That is 7.1a. We feel that there should be an addition there. Discrimination shouldn't be against a victim on grounds of relations. Relations, if I should expand a bit why we need to incorporate that, it's because sometimes there are certain provisions that are made considering the relationships that victims have with the people that have committed crimes against them. And that would sometimes be a form of protection against such people. And we also wish to include pregnancy in that area. We move to protection from gender-based violence, that is 12. And we feel that 12 does not have, it does state that there will be women and girls are accorded protection from gender-based violence, but there's no specific mention of the responsibility of government, maybe on safety homes. So we feel that is also a necessity that government takes care of that aspect. We move.
Safety homes are already provided, Honorable Member.
Where?
Right, if you go right down to prevention, protection, and other measures. Interventions, so we provide extensively for safety.
Thank
homes. You. Yeah, it's right towards the end of your GBV model.
Thank you. 14, equality, privacy, dignity, and respect. 4 reads, a woman shall not be discriminated against with respect to the provision of housing or any attendant service due to her having survived gender-based violence, and the landlord is prohibited from evicting her or refusing to rent a house to her because she's a victim. We feel there should be additional comment there or wording that indicates provided the financial obligations are catered for. Otherwise, it reads as if landlords cannot evict just on the basis of gender-based violence. we move where are the other ones? And there's a general observation. If we look at 23, protection from exploitation and right to sustainable livelihood and employment. That is not the only part. 23(6) of it, where it reads of a person who contravenes any measures put in place in accordance with this section.
Honorable. Angola, kindly mute microphone, or IT, kindly mute Honorable Maria Nascimento's microphone. It's interfering on this end. Thank you.
Thank you. 23(6), a person who contravenes any measures put in place in accordance with this section commits an offense and shall be liable on conviction to a fine not exceeding XYZ, XXX. Throughout the model law, we sometimes have part of a fine, and sometimes we have time provided, and we wish to include that it can be fine or imprisonment or both, so that it's a choice to select from the three, not just one. And that runs throughout the model law in the area where there are fines. Thank you.
Lesotho. Okay. Thank you very much, Lesotho, for those inputs. Is there anything to consider from Lesotho's contribution, or we shall proceed to the next country?
We're proceeding to the next country, Madam.
Okay. Malawi?
Thank you very much, Madam SG. Firstly, I would like to bring to your attention the fact that Malawi does agree that we need to modernize our existing laws that deal with gender-based violence. And that is why we are happy this has been introduced. A few things that we would like to bring to your attention and everyone's attention. I will sound like I'm repeating, but I might rephrase some of what has already been presented. First of all, this should have been done at the very beginning, whereby we needed to seek clarification so that member countries should understand what we are getting ourselves into. The clarification on the difference between model law and other treaties, because that is also where the bone of contention is coming from. If members had understood the difference between that, I'm sure I would have avoided some of the headaches that we had. Secondly, how binding is the current model law compared to other laws that have been passed before? Because other member countries, especially maybe those members who are joining us for the first time, they might not understand how binding this document is for their countries. The concern is that other stakeholders, who some of them might be here, the other biggest concern is that maybe they might be taking what we are discussing here as a binding entity and use it against us, either as endorsing their agenda or not abiding by the treaties we have signed with other entities. So there's also a little bit of suspicion, but if a few things had been clarified at the very beginning, I'm sure would have made good progress. Secondly, is that the model law, I would like to find out how the model law relates to other laws that have also been passed, either through SADC-PF Have we done early child marriages? Have we done HIV and AIDS and so on? What phrases were used in those model laws? How contentious were the arguments there? What should we have avoided by looking at what we have done? Maybe a background could have also been provided so that we could have avoided some of the things. Thirdly, the major concern is that this model law may have legal implications. That is why we would really want to agree with other countries that some of the words needs to be rephrased so that the model law should not be seen as binding. Some of the people who have done law or understand law, they know that words like shall, must, should indicate that that thing is a must and it's a binding thing. If there's a way of rephrasing those words, maybe other member countries might feel that this document is not binding. So we need to take a look at that, and that applies to the entire document, Madam SG. Additionally, the clauses that are talking about lesbians, gay, or LGBTQ should be redrafted and have a neutral phrase. Using the term marginalized, for example, which we believe is a neutral term, can be used. We as Malawi do understand and believe that indeed every country will contextualize the model law depending on their values, principles, and all factors that form the process of legislation and domestication in their countries. In that way, we would bring on board our differences and each country will adapt and adopt accordingly. So if we can be able to avoid contentious phrases and let the countries expand when they are starting to operationalize it, will help us to move forward. Another point is that in the event that the validation exercise is not concluded within these 3 days, the Malawi delegation does not want this issue to go further and have the discussion on Zoom in case we are not going to be able to meet. We feel that the document should not be rushed because of issues that are contentious in nature. If there is a need, members should be allowed to consult further, reflect on what has been discussed here after hearing from what other countries are saying, and propose further amendments. And we need to have the consultant take this on board, because our understanding as Malawi is that this is our document and not a consultant's document. In view of that, we need to be given enough time to hear what others are saying and also to go back and discuss with our colleagues back home. We also noted at the very beginning that the consultant said the National Parliament, the drafters, were engaged. Had we known much earlier, we would have also requested that they should have been here with us so that they could take us through what they discussed with the consultant. If there are other issues that are different from what the final document is saying, from what they presented, then would have also been able to make informed decisions. But in the absence of that, we will move forward, but with a little bit of reservations, because we strongly feel that after our 2-3 days discussions, we need to go back and compare with what was submitted to the consultant at the very beginning. In conclusion, as much as it is seen that the agenda is on gender-based violence for all, it also seems that there are also some elements of hidden motives that keep popping up here and there, looking at how some phrases and opinions are being met with resistance to be accommodated, and would not want to be seen as promoting a specific hidden agenda. Therefore, this document should not be rushed, but cleaned accordingly. And if possible, this document has to be circulated again to all the member countries before it is presented to EXCO on December 11, because this is going to be presented for the entire plenary to adopt. This, Madam SG, is the presentation of Malawi. Thank you.
Thank you. Thank you very much, Malawi. Shall we have the next country? Mozambique.
Muito obrigado, Senhora Presidente.
Thank you, Madam Chair.
Senhora Secretária-Geral.
Madam Secretary General, we
consideramos que esta
consider that
proposta de lei modelo
this proposal of a model law corresponds to that which are the apprehensions and the concerns that we live
no nosso país.
In our country.
E creio que para também
and I believe that for many a country,
deste fórum,
members of this parliamentary forum, such is applicable to. The constitution
do fórum parlamentar
of the parliamentary forum, of the SADC parliamentary forum, I believe that
no seu
in its
capítulo 3º dos objetivos do fórum,
third chapter to do with the forum's objectives in Article 6,
nas suas alíneas B e C,
in B and C, if we consult such,
indica que
it indicates that
define o seguinte:
it defines as follows: to defend the harmonization, ratification, integration, and implementation of protocols.
French is on the wrong channel interpreter.
Desculpem.
Can French hear? Yes, because the interpreter, you're on channel 5, the wrong channel. Kindly test. Non, écoutez.
Oui, maintenant, je vous attends bien.
Okay, thank you very much. Let's proceed. I'm speaking broken French, but...
Há muitos problemas técnicos. Certamente. Muito obrigado. Então, eu dizia...
I was saying that
a Constituição,
the Constitution, our Parliamentary Forum Constitution,
tanto nas suas alíneas B,
in B and C and the 6 indicates that
nós temos que defender a harmonização, ratificação,
that we have to defend the harmonization, ratification, and implementation of protocols, treaties, and other SADC decisions.
promover os princípios.
In C, we have to promote human rights principles. Therefore, I take this point as a very important point in order to contextualize that which we are doing here.
Por isso,
so,
não temos,
we,
no nosso caso moçambicano,
in our Mozambican case, we have no objection. For us, this law, this model law, does not in any way injure our Constitution of the Republic in its essence. Therefore, we have no fundamental observations that may make difficult a positive consideration of this law in our country. This brings to us important aspects which will assist us legislating matters of this nature without any contradictions with our Mozambican law. So I would like them to agree with what our what was said by our colleague from Malawi. Also, I would also make reference to what was said by the lady MP, the Honorable from Angola. We are therefore in agreement with the proposal which is put forth. Thank you.
Thank you very much, Mozambique. May I kindly have Madagascar? I just looked and forgot to follow online. Apologies. Madagascar.
Thank you.
Je suis désolé.
Non, c'est pas oublié.
Very sorry. Okay, it's fine. We are just a bit. We are fine. We would like to make comments globally. The honorable members in Madagascar, the parliament has already approved a law related to gender-based violence dated 13 December 2019. There is also a draft law which is linked to nationality code, which I had to present myself. There was a training workshop which was organized by the Caucus to revise. That was on the 3rd and 4th December 2020. Linked to statelessness, we support the efforts which were done in Madagascar and the focus for the development of institution for development with the system of United Nations institutions so that there can be a code linked to statelessness. And in order to avoid all the controversies, and I had to make a lot of explanations during press conferences to clarify everything. My colleague, Honorable Chairperson of Gender Committee and other committees, who is also Vice Chairperson of the SADC Parliamentary Forum, proposed also a law about pregnancy, and she met similar problems with the public in general about this gender-based violence law, which is proposed by the SADC Parliamentary Forum. For the time being, in line with what I have just said, and also considering our customs and cultural habits, we need to also to include vulnerable groups like heterosexual, lesbians, transgender, non-binary people in the model law, which is proposed. Myself and the population of Madagascar and all the honorable members, we would like to delete all the contentious terminologies, regardless of the globalizations and the laws linked to gender and human rights laws. We would like to everything to be in line with our customs and our culture. This is what we had to say as Madagascar delegation, and I thank you.
Merci beaucoup. Thank you very much. May I now kindly have Malawi? No, I've had Malawi. I wasn't following. Mauritius? Is Mauritius online? Okay, we move to Namibia.
Mauritius, yeah, online.
No, Mauritius. Is Mauritius online? Mauritius is not online. They are checking, I can see. No representation from Mauritius. We'll get back to them if they're online. Let's kindly have Namibia.
Thank you. Thank you very much. I think maybe let me start by a comment saying many of the integrated comments has already been said, and it will sound as a repetition, but I stand just to be guided in terms of the caucus. I do confirm that we have met all the delegation of Namibia. In terms of page 52, subparagraph 1, that has been taken care of. Then at clause 3, which is where the discussion then stopped, we submit that maybe we should stop in terms of not treating this document as a model law, because in our definition and understanding, and it's not our intention to impose our thinking, but in our definition and an understanding of a model law, it's a centralized law that is there and disseminated for the different independent respective jurisdiction to work on and improve. So for us, in terms of that understanding, a central or a model law cannot have a very distinctive description about subject matters, but it should serve as a guiding document. Not saying that, also there is the word, maybe legally, of paramount importance is the word shall. When the word shall is used in legal terms, it implies to an imperative command that must be performed at all cost. The word shall, when it's reduced into a legal document, does not give any other option than to enforce the command or the provisions as stated in the law. So that's also one issue that we wanted to touch on, because on paragraph 50, on page 52, paragraph 4, it says the rights and benefits, protection, interventions, assistance, and services referred to in this law shall also apply and be available for victims who are repatriated from one member state to another. Now that shall is imperative that once we ratify or give consent to this document, then as a sovereign country, we shall be able to provide that particular citizen that is repatriated from another jurisdiction into our jurisdiction. We are mandated in terms of the law to provide him the same privileges and definitions. When we go to conflict on page 53, it says the government shall amend any provision, again the word shall, of laws such as family, divorce laws, property, housing, social and employment laws that contradict or are inconsistent with the model law or any law on gender-based violence, so as to ensure the consistent legal framework and promotes human rights and gender equality and eliminates gender-based violence. Now it becomes imperative, again, the word shall. The government shall amend any provisions. It's a mandatory that once ratified, we have to go back and amend any laws pertaining to that. On page 54, subclause 4, extraterritorial jurisdiction of laws, maybe just a clarity that we are seeking, where it states the member shall ensure that any law or gender-based violence shall have extraterritorial effect so as to the meaningful effect to the certain obligations and commitments made by the SADC member states under I can't see that word, instruments, under international instruments relating to gender-based violence. The law shall apply to any offense committed outside the territory of the member state when the offense is committed. The law shall apply to any offense committed outside the territory of the member state. Again, as we are saying, we are addressing these issues, but certain key legal imperatives are emanating in terms of the word and the legal framework that is so required. On objectives, I think we accede and we accept, and we are going to page 56, interpretation. There, under the definition of domestic violence, means any action or omission based on gender perpetrated by a family member, the consequences of which or may cause harm or suffering to woman or child. Men are excluded. And we are saying perpetrated by a family member. What if that person is not a family member? Or maybe the definition of a family member. Because as it stands in terms of the legal understanding we have developed, domestic violence becomes only a crime once it's perpetrated by a family member. If not a family member, then maybe it's classified differently. And there we benchmark and research or refer to Act number 4, the Domestic Violence Act number 4 of 2003, to be more specific, section 3, for reading so as to understand for the drafter as to what we are saying. And that is the Namibian Act, Act number 3 of 2003. Then maybe just an observation on page 58. Gender means the roles, duties, and responsibilities which are culturally, discrimination 57. Yeah, discrimination means any distinction, exclusion, or restriction made in any ground specific in section 7, which I will go to, which has the effect and purpose of impairing or nullifying the recognition, enjoyment, or exercise by a person on the basis of equality with another member of the community or human rights, fundamental freedom, any entitlement, privileges, measure, or intervention provided or made available to the person to mitigate the effects of gender-based violence. When it comes to gender, the definition means the roles, duties, and responsibilities which are culturally, socially attributed to women, men, girls, and boys, or gender. But the next line where it says gender-based violence means all acts perpetrated against women, men, girls, and boys on the basis of their sex. We thought the description of gender-based violence should be the one that suffices and not the inclusion of women, men, girls, and boys, or gender. That goes also to what is captured there on gender equality. It also has got the word or the description of men, women, girls, and boys, or gender. And so the document, wherever it refers to that classification, needs to be addressed.
I don't know, Madam Chair, are we using two different documents? Because the documents that we are supposed to use is the tract document which was sent to all member states. The tract version, you are using the original document before your representatives made these changes. Because what you are reading has already changed.
Yeah, no, I think when I started, I said what I've said could have been already been done or captured, but I was just following in what was required from us in terms of the break to go and engage and then to report back.
Okay, I think what the
gender roles. Huh? Yeah, no, the drafter took me a little bit off guard there. But being born by a woman, they always.
No, I think the issue to check is that The member seems to be referring to the old document.
Which one is now a new document?
If the things that he's saying are already captured, let him proceed on the basis of what we have discussed, on the basis of that document. Then an answer can come that this that you have addressed at this and this point have already been captured. Because now, unless you are going to give him that version for him to go and rediscuss and come back again. So let him continue on that basis.
Because all 5 of us consulted the same document. I mean, the Namibian team, we were just having the same and we were together. I'm just delegated to be the spokesperson, but I think all 5 of us were reading each one from the same document. Okay.
Yes, I'm just, yeah, no, it's fine.
Now the specific clause of section 7, protection from discrimination. The government, a competent authority or judicial institution, an appropriate authority, a service provider, traditional or local leader, and all other person shall not discriminate against a victim on the grounds of race, color, sex, sexual orientation, and gender identity and gender, age, and so forth. Those are the issues that we say. If we have agreed in principle, then in terms of the understanding I have, gender identity and gender should not be part of that description. We further say the competent authority, judicial institution, and an appropriate authority and a service provider shall display at their premises of work information on its non-discriminatory policies and practices. Are we saying when we come here at Protea Hotel, or what is this one? Premier. And Premier does not display lesbian or whatever. Are we saying Premier as a service provider is then in breach? I'm not a lawyer, but I was, in terms of the reading, that is to the little I wanted to have the effect and the understanding. Are we saying when Premier does not display that as a service provider, we are saying then it is in breach? So, because it says all authorities, judicial institutions, and service providers. It further on goes and say, and there we have got a fundamental problem, to say a person who performs any function or exercise any power of a competent authority, law enforcement, judicial institution, and an appropriate authority, a service provider, traditional or local leader, contravenes subsection 1, that particular person shall immediately be arraigned and appropriate punishment be imposed on the person in accordance with the law. Are we saying now our traditional leader, the chief, if he does not recognize the same-sex marriage, or if he refuses to preside over a dispute of a same-sex marriage, he can then, by virtue of this, be held liable for breach of this contract. Because that's, from that reading, that is what that is the understanding I'm developing. So, and therefore it will be unfair and practically not fair and just, even for a traditional leader, whom, when we are saying some of these things are not even describable for them. Now, let alone you allow a person who he himself does not understand to preside over a subject matter for which he is not competently and duly having a profound opinion over that. We go to access of justice, and we say, subclause 2, maybe just as an explanation, a victim has a right to execute judgment against the state after 1 year of judgment, if no action is taken by the government as provided in the judgment. This terminology is very new. I've got a son who I disowned because of our quarrel or whether he's whatever. This son takes me to court. The court rules in his favor. After 1 year, my son can come back, or whoever can come back and hold now government accountable on a subject matter for which he does not have jurisdiction. It's my will to say, I'm going to let X inherit. I've got 8 kids.
So X must take over. But if I made known that I don't give it to you because of whatever, your binary status or sexual orientation, that is the word I find here, and the court rules in his favor, then this is the practicality. You see, we are saying we have read the document, we understand the legal issues, but we also, there is the legal matter and there is the interpretation of the law and the intent of the law. Is that the intention of the law to achieve that? Furthermore, we say traditional authorities shall, when handling matters relating to gender-based violence, ensure as applicable, they apply the procedure and norms relating to access of justice. Maybe just as an explanatory note. Then on the right to life, I think this one is not that severe, but we have seen in our courts when the law prescribed to them to pass maximum sentence, they tend to have an opinion to say the law cannot prescribe to them what to do, because now it says a member state shall ensure, though through law, and in particular where a person is deprived of life because of a gender-based offense, that the perpetrator is sentenced to maximum possible penalty provided for in the offense. So in our case, there are cases before the court where the court says the law cannot prescribe to court what penalty should it pass. It can maybe indicate, but it cannot prescribe. This one, I think Honorable from Lesotho also touched on the prescription of XX, but there it was saying not the minimum, but here it says whatever act emanate from there, and the verdict is a guilty one pertaining to the perpetrator of domestic violence, the subsequent penalty must be the maximum one. Now, on the basis of that, I think 29 also is an issue for us to submit to the plenary to say it's not practical. If we are of the opinion that maybe we should be enlightened how practically we can implement the aspect of a non-open court in terms of the judicial system that we follow. Having said that, brings me to the issue or general observation that we said, and I think it was alluded earlier by the Honorable from Malawi. If we had been aware that our legal drafters was consulted, we would have come with them here. We also made a call to them, and we don't want to put words of others against others, but we just say it would have been best that all the others who were consulted, we could have come together and seated, and then we can be taken through and address the issues as they emanate. Furthermore, I think it was best we applaud the people who organized the face-to-face intervention. I want to submit that if it was not face-to-face and virtual, I don't think we could have been having the same understanding and interrogation of these hardcore issues as we are doing it now. And lastly, they say the only way to face a problem is to face the problem, unfortunately. Thank you very much.
Thank you, Honorable. Yes, thank you very much. May we move on to, there are areas where there's need to respond, but because this is really submissions from countries, I believe that we'll rest at that point. Let me allow Seychelles.
Thank you, Madam SG. Okay, can you hear me? You can hear me? Okay. Okay, for the part one, domestication of model law, one, where we amended the shall and the may. We replaced the shall by the may. While we discussed, we felt that shall is binding, but may is not binding. And from a legal perspective, the shall would be more appropriate to be used On the next page, on the next page, part 3, the contentious point here. We Seychelles want to put on record that we don't agree to remove the lesbian and the LGBTI. We just want to put it on record, as we felt, as this law says this morning, that we have signed the Vienna Convention, especially we should pay attention to Article 53. We have also signed the Brazzaville Commitment and the Abuja Declaration. But having said that, the amendment that was brought forward by Eswatini, we felt by putting the, can we have it on screen, please? 3. Application and scope. 3. The one we were discussing this morning.
I think the 3.
Application is number 2, but the point number 3 we were referring to. It's page 52, I think. Yes, this is the one. But we felt the amendment that was brought forward by Eswatini can be considered as marginalized group. It will encompass all. And can also be conceptualized by each member state. We move on. Objective. Objective, the C, ABC. We felt that here we wanted to make a small amendment to insert after nationality, to insert sexual orientation. And in definition, interpretation, domestic violence. We felt that here we could include on the 3rd line by saying the consequences of which cause or may cause harm or sufferings to a woman. Oh, it has already been amended. Okay. Now we wanted to put men also here and children. And the next page, gender-based violence. We wanted to add after harmful act, practices, harmful act and practices directed at individual. On top, it's amended, a harmful act and practices. And again, harmful practices, definition, the next page. Harmful practices. We wanted to add, after sex, a comma, gender, or sexual orientation. Sex, remove the or, gender or sexual orientation. And because further up, yesterday, we used the word rehabilitation. I don't know if you want to add the definition of rehabilitation as we go along.
Yeah, you saying in the same definition, Honorable Member?
Yeah, because we use the word rehabilitation institution, we want to insert the definition.
Oh, creating a new definition of what?
Of rehabilitation.
Rehabilitation, okay. Please,
something is happening.
Apologies, there's a point of order, but we set the rules area. Honorable Zede.
These rules are being biased. I see double standard. When the previous ones were presenting, even when they wanted something to be deleted or what, it was not done. Now, the drafter is only listening and making adjustment to only one person. What is this? I just want to know. Please assist. Maybe I don't understand what is happening in this room. Will you please assist me? I beg you, honorable members. Is this what I'm seeing in my eyes? Or is this always happen? Because you have already said they are from once in this room. We have come here for the first time. We don't know the rules and laws. Excuse me. So if that is the case, then you are doing things the way you want. Others are favored, others are not. Is this a meeting, a regional meeting, or a one-sided meeting? I need an explanation right now, please.
But Madam SG, but this is what I understand after the meeting we had this morning.
Honorable members. Which amendments that have been proposed have not been captured?
Many.
I believe that there are those who are making amendments directly onto the text. The other members who are making submissions, which we have to consider, and then go back to take their input into consideration. I need assistance if there's any amendment that a country has done that has not been taken on board, because submissions require consideration and then seeing how best that can be done. Is there a country whose amendment has not been taken on board? I'm asking leaders of delegation, which of your submissions has not been taken on board?
SG said. SG.
I can't hear.
Yeah.
Okay, we agreed on the rules that the leaders of delegation.
Well, my leader of the delegation is not here, so I will step in.
Members, I'm trying to avoid. Yes, I'll come back to you, Honorable.
Okay.
Leaders of delegation, which of your amendments have not been taken on board? It is important to differentiate between the two submissions, that the style of submissions that is being made in this case. And if there's an oversight on my part, I need your guidance. Okay.
Thank you, SG. When the rest were presenting, the drafter was responding that I'll do it later, then highlighted, and then it was left as it is. Right now, when the immediate presentation was being done, she's busy removing, adding, whatever. Now I'm asking, is this double standard or what? Are we on the same track? That is my only question.
Okay, Namibia, Honorable, is it? Yeah.
Honorable SG, it's fine. I think the Honorable Chairperson touched what we wanted to say.
Yeah, I believe we must proceed, honorable members. We will go through the document and we shall, if you have made any formulations or redrafting and it is not there, you will kindly assist us. But where a submission has been made globally in terms of the submissions that I've been looking at here, it would require more time to look at. However, where a member is saying on section 3, where you've written for the avoidance of doubt, I want you to put a full stop or a comma or whatever. This is what the drafter is doing. The others have been noted, but will be taken on board. I just wanted us to look.
Honorable.
Was there something different?
Honorable SG.
Which one?
Honorable SG.
Let us.
The major comments from the persons who are making submissions were overall in relation to reconsideration and things like that. Where they made a specific reference to a clause, I actually took it into account. If you go to 3, which was the major submission out of all of them, you can see I've deleted all these heterosexuals, blah, 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 as they wanted, and I've highlighted it. And if you look at the comment, is here, remove. Avoid contentious issues, remove. So this will be removed. So I've taken into account all the submissions that were being made directly on the text. Yes, there's other country submissions which were being made. The rapporteurs have, just give me that. The rapporteurs have recorded each and every submission that has been made for the report. So there's no submission which has not been recorded, SG. All the submissions have been recorded. And where it's directly to the text, I've done all of them. You can see the mays, the shells, everything has been done here. Some member think it was, they said they didn't want women's, they wanted human rights, I deleted. I've taken into account everybody, so I'm very surprised, Honorable SG.
No, honorable members, let us agree that your comments will be taken on board.
Please, I think, Honorable SG, can I go ahead? Yes, I think we must understand this complaint in context and properly. See, the contentious issue or issues are not just what was contained in that section 3 or subsection 3. I think the contentious issue, as I understand it, is the reference to binary and sexual orientation and the mentioning of the rest of the things. Now, what brought this observation is that notwithstanding the fact that there is that contention, there comes a suggestion from, was it Mauritius? No, it was Seychelles. There's a suggestion from Seychelles that says, let's put in there sexual orientation. And that was then captured, notwithstanding that since yesterday, these very issues are bogging us down. And the context of this complaint from the chairperson, as I understand her, is that there is a perception, or seemingly there is I don't want to use the word attitude, but there's a readiness, I should say. There's a readiness from the SG, from the presenter, to readily accept proposals that advances or further entrenches those issues in the document, and a reluctance to accept the suggestions that says, let us not include these and they are not necessary. So this complaint is coming from that context. And unfortunately, we must accept that there is a perception and there is actually action, perhaps unwittingly, from the presenter and by and large from the SG. There is this portrayal, but you are portraying a desire to readily to try and explain why there's a need to have this, when clearly those explanations are not being accepted. I'll give you one example. No. Chair, you have not stopped anyone.
No. Yes.
No, let me just complete. Let me complete. Let me complete. The example that I give you is this. Earlier on when I was speaking, the honorable member from the Seychelles actually heckled me, basically raised her voice at me, and I had no protection. That tells you what? It tells you that the chair should have met that conduct with I don't want to say rebuke, it's too strong a word, it should have called the member to order, but that did not happen. What perception does it create with those members that are in agreement with what I was saying? That the chair is actually in favor of that submission being disturbed by member. I actually had a conversation with her, and of course, luckily SADC Parliament is in Namibia, and we know each other's capabilities, even if I did not respond. So that perception is there. And the mere fact that you are readily able to capture the inclusion of sexual orientation, even when the mood is otherwise, is what brought this complaint. Thank you.
Okay. The sexual orientation. The member from Seychelles actually made a direct amendment. My expectation is that once the member proposed sexual orientation, there would be a hands up from the other members objecting to the insertion. I can't do it. I'm not an honorable member. I'm just a drafter. So once the member says they want it in, we put it in, and we expect the honorable members to object. I can't object. I have no status to object.
Okay, honorable members, we are going to create a very difficult situation. Are we now proposing that we only listen to one side of the submission? Or are we taking every country's contribution on board?
Every country's contribution.
If that is the case, then we cannot ignore. We have not ignored any country's submission. Seychelles made a submission. The drafter, and I keep hearing that this is not the drafter's work in terms of, this is not the drafter speaking to you. This has developed from all the process that we agreed. At the end of the day, you can tell her to leave, and she will not influence this draft anymore. We can sit here and do it ourselves. Let us be fair to all the countries and the process. The drafter is only doing her job as instructed by members. So in this case, are we saying we should just, even if a member says in this paragraph, amend as follows, the drafter cannot ignore the member. We will come back to these issues as we have agreed, that we will then begin to say, how do we tackle this finally? There's a proposal. In fact, I thought we should have stopped at the point where Malawi, if that was the case, would have stopped, because Malawi basically said, let's get more time. If I stopped there, would I have been fair to all the members? I think let us look at these things to say we are all contributing as countries. Otherwise, it's very difficult. I don't know what instruction to give the drafter now.
SG, you have gone far. We don't have any problem with the draft. We like the document, and that's why all of us are busy with the document since yesterday, and even 4 months back. We appreciate the work. That is very true. But then that does not close it, or that does not stop us from giving our views for things which are happening in this room. We want the same drafter. Eva is she's a guru on her job. This is a good draft. That we agreed. And may I tell you, and I said it in the morning, for a learned sister to be a drafter is not only just she's learned. You have to go further and read more. So she's different from the rest of, I know we have draft people in our country. I know how tedious is that job. I highly commend her and appreciate. Now, let us not mix things. Let us be objective. We are not talking talking to the drafter as ever. We are talking to the work. And what I mentioned earlier is that there are people, when they are, they are honorable members, when they say things, it is immediately adjusted, others not taken. Then you explained, enough, if that was all. So I am comfortable and the rest, but matters taken.
Yes, we are trying to resolve it.
Message sent.
Yes, we are trying to resolve. What should the drafter do? What should the drafter do, honorable members?
No, just listen to us.
She mustn't draft. She mustn't correct. She mustn't take what Seychelles is telling her.
Now, if that is the case, why other things were written aside and the others changed immediately? That's my question. Does it mean that the other things were more important than the other?
No.
That's what I asked.
Okay, no, honorable members, it is not so. It is the nature of the comments that are submitted.
Agreed.
Yeah, okay, thank you very much. Let us close the debate. Let us continue, Seychelles.
Yes.
Thank you, Madam. Sorry to say, I'm not the one giving orders here. I'm only executing what we agree to do this morning as a member. And I'm reporting back from what our members from our country discuss. So I think I have the right to report back the views from my country, be it you accept it or not. I have sat here and I have listened to every one of you do your presentation. Okay, with due respect, let me finish what I have to say, and then if you disagree, you can disagree. But at least I would have said it, because this is what our country discussed and what members has put forward. I cannot amend what we have put forward. I cannot give my personal view, but I have to give the view of the members. Thank you.
Before we went for tea, we agreed that we respect each other's views. Whether we agree or disagree, let's give each other an opportunity. I think we've done very well. And it is not fair that we before we finish, we are stopped. We've been allowing for all the countries to submit, and then we move to the next country. May we kindly proceed in that manner?
Yes.
Thank you. Seychelles,
thank you, Madam SG. The next chapter is 11, right to life. No, protection for gender-based violence, number 12. Where it reads, women have the right to refuse sexual acts, including act within marriage and relationship that put the woman at risk of infection, such as HIV or the sexual transmitted infection. We wanted to add or hepatitis C there. And have the right to refuse any act not desirable by her. We wanted to add hepatitis C there. Yes. And further down at 6A, where it says woman and girl, we wanted to say woman and children, because we find it is not gender neutral. Woman and children. And again, for E and F, we felt that it is not gender neutral. And ENF. Well, it says protect women against all kind of gender-based violence. And further down, violence against women is condemned. We felt it should be women and children. Anyway, a suggestion.
Honorable Member, in some of them, may I just highlight them in yellow so that we consider them at the drafting stage? Because some are special protections, others are for all gender. So can I just highlight those words? Is it okay by you?
Yeah. And on 13, protection for inhumane. We just wanted to know if you were using the British version. Inhumane. Protection from inhumane treatment. 13. After J. In the title, protection from inhumane treatment and security of persons. We just wanted to know if using the British version. Okay, we move on.
Could we kindly switch on the air conditioner, please?
What? No, we're just asking a question. Okay, so we move on to the part. Okay. Right to education, 18. G, 18G, 4G, 18, 4G. Where it reads, preventing sexual abuse of women and girl by teachers. 4G. Of women and girls, we wanted to put children, women and children by teachers. Because we felt that boys also could be abused. Okay, we wanted to add teachers or counselor. Preventing sexual abuse of women and children by teachers and counselors. Okay, we move on. This is the last one, right of health, right to health. 6, number 6. Okay, where it reads testing and treatment for women and children who are pregnant. We felt maybe it could read that emancipated minor instead of children. It's only a suggestion.
Honorable Member, I didn't get you quite. Honorable Member, if you can repeat your...
Allowed women and children. No, okay. Testing and treatment of women and children who are pregnant. Children who are pregnant? We had a query here. Is it children? Is it adolescent? Is it emancipated minors? It was on here.
I think we use the same term as in the model law on the child and children already in marriages.
Okay.
We just use the same word.
And the last one.
What was defined as children.
Yeah, okay. The last one. Right to employment and social security. Number 4. We wanted to know why the 15 days. Is it the golden standard or why the 15 days? Why we wanted to question this, because further down where it has written for what? For the sanction, it was XXX, so the country would decide what to put, but there we say, you put 15 days. We wanted to know the rationale better. We wanted to know the rationale.
Honorable Member, I think the XXs are better.
Okay. Okay, so this was the last one. Thank you. But what we felt, Madam SG, we said that maybe whether a point of contentious, maybe countries could bring amendment to the plenary to be further discussed. And we felt that this law, before it is approved, we have to go back to our national country and discuss with other members of parliament and legal draftsperson. Thank you.
Are we going to the next country?
Yes, please. I was hearing some. Okay, we move on to South Africa. South Africa is going to join us online to do the presentation.
Thank you very much, Madam SG, honorable members and delegates. Thank you for this opportunity to share South Africa's position on the draft SADC model law on gender-based violence. The development of this model law.
Honorable members, may we kindly give the member opportunity to, yes, thank you, kindly proceed.
Thank you, Madam SG. The development of this model law is incredibly important and timeless, as we know that GBV has been a pandemic for many years, which unfortunately has worsened significantly during the ongoing COVID-19 pandemic. In South Africa, we have had heart-reading testimonies from survivors of gender-based violence, listened to faith-based groups and student organizations, and had representations from business, labor, the LGBTQA+ community, and men's groups. We have agreed that the rights of women and children are inalienable and must be both upheld and enforced. We also understand that the drivers of gender-based violence are diverse and need a multi-faceted response that includes all sectors of society. Indeed, the fight to end gender-based violence is both simple and high complex. As South Africa, we also understand that as SADC-PF is not yet a regional parliament with law-making powers, its model laws are not binding. They are meant to serve as legislative yardstick or tools for member states to consult during any domestic legislation development and or amend endeavors in a particular policy area. Member states are able to choose which aspect of a model law they would like to use or not. Regional model laws can therefore serve as valuable tools in the region's integration efforts, notably in terms of the harmonization of member states' political and socio-economic policies. We therefore, as South Africa, welcome and appreciate the work done by the drafters. In this light, South Africa supports the draft model law and the international, continental, and regional human rights principles on which it rests. We believe that we as SADC countries have much to learn from each other on how to address this pandemic, and we appreciate the opportunity to engage and contribute to this model law that is already pledged to be the first of its kind internationally. We understand this is a non-binding tool and a legislative blueprint of countries to aspire to. And we look forward to see how it will shape the rights and protect the most vulnerable of women and children in our region. I thank you, Madam Chair. That is our input as South Africa.
Thank you very much, South Africa. We now move to Tanzania.
Thank you, Madam SG. The first point that I want to raise is that most clauses in this model law are very relevant and they are good. And in actual fact, they are going to help us in enhancing our domestic laws in terms of fighting GBV. The reason that's why Tanzania has always been in a position to ask for the SADC to delete the words in section 2, subsection 3, which mentioning lesbian, same-sex relation and the like, is that we don't want to lose these relevant clauses back in our process of domesticating in our country. Because as I said yesterday, inclusion of these words, of this sentence, lesbian, same-sex relation, just inclusion of that in our country, if that sentence is seen in the document, the whole document will be thrown away. Nobody will draw attention to that document. That's why we wanted to be removed so that we cannot lose the good clauses that are in this document. So you should understand us from that position, because we have seen a lot of relevance, a lot of good clauses, good points, and we want them. But if you include this sentence, the whole thing will be thrown away. That's why we wanted this to be removed. And thanks for that. Section 2, subsection 3, this sentence has been deleted. So we don't have any problem with that. And when we received the first draft on this model law, we gave our opinion on 10 clauses that we wanted to be redrafted and some of the words to be removed. And looking on the last draft, most of these comments and opinion has been taken on board. And I will mention the few. Clause 1, I mean section 1, subsection 1, 2, up to 4. Our issues has been addressed by replacing shall by may. All subsection 2, 3, and 4, as we agreed in the morning, the word shall will not be used, and instead we'll use the word may. And only that will address our concern on section 1. And then in section 3, if you look on subsection like 5, you'll see that it's mentioning the government would propose the SADC member states as opposed to government, because the government can change anytime, but the member states will always be there. So if you use the government today is there, tomorrow another government can come in. The city should be SADC member state, not the government. Because
members, we just agreed, honorable members. We just agreed that please allow members to conclude.
Otherwise, in this section as well, the use of may has addressed our concern. On section 11, subsection 3, we have notes that there are some conflicts between this subsection of model law with our laws in our countries in some areas. For instance, 11 subsection 3, it speaks about death sentence, removing the death sentence. But in our country, we still have death sentence. But this one will be addressed by the fact that this model law is not binding. And section 12, subsection 3, the model also conflicts with our Marriage Act, because in our Marriage Act, there's no rape within marriage. There's no rape within marriage. That's our country Marriage Act. So the wife cannot say that he's been raped by his husband. In our Marriage Act in Tanzania.
Order, honorable members, order. Order, please. Let us allow Honorable Zede to finish, please. We agreed.
Yeah,
we agreed, yes.
I'm pointing out the situation that exists in our country. In our country currently, our Marriage Act states like that. But the model law, it says that a wife can sue the husband if the husband using force to have sex with her. I mean, a rape act. But in our Marriage Act in Tanzania now, there is no rape within marriage. That's a fact in Tanzania. That's what I'm saying.
Honorable members, we will have an opportunity.
Yeah.
We have to allow Honorable Zede to contribute and finish.
What I'm saying is what is existing in Tanzania. On section 19, subsection 4, the way it is now, if you check 19 subsection 4b, it sounds like it gives sexual rights to children. But if it's not, then we are okay. And section 19, subsection 4d.
Honorable Zed, I think you moved too quickly. You said which section before that? You said section 2.
19, subsection 4b.
Okay.
Those rights that are granted to women and children, it looks like children are also provided with the sexual rights.
Madam Chair, I think the SADC-PF adopted the model law on child marriages and children already in marriage. And this is what it says in that model law.
That is why I needed to go. So there's a problem here. Let us allow Honorable Zede to finish.
Our suggestion is to remove the word sexual and the rights. The two words should be removed from there. Sexual and the rights. So it will lead us.
If you can go back to the heading. Yes. The minister responsible for health shall, in consultation with the government, put in place health policies, special measure and strategy for women and children, which ensure the following. So whatever is insured is for both women and children. So if we ensure sexual rights, it means for both women and children. So you cannot ensure sexual rights to children.
The word section of rights should be removed.
We'll get back to that one.
And then D, and then D, D, abortion services. In our country, abortion is illegal. But this model law is encouraging putting the facility that will allow abortion. So we propose abortion to be removed. And then section 14, subsection 5. 14.5. It speaks about the rights of the landlord, but we want both landlord and tenants. It should be on both sides. But here it's give the right to only one side, not the landlord. Because the same abuse can happen to the tenant, not against the.
The request is that it should apply both. It should be two ways.
We should refer both landlord and the tenant.
But who holds the house? Who can give a? Okay, let's proceed, Honorable Zede. Kindly just highlight that and yeah, thank you.
Another point is clause 18, subsection 4. I think we support this, the issue of school re-entry for girls who get pregnant. I think there's no problem, we support that. And clause 21, subsection 1. We also support the right to nationality.
Where you support we, yeah.
Yeah, because this is, I think this is more relevant because currently in Tanzania, a Tanzanian woman cannot confer her nationality to her spouse. Yeah.
Cannot confer nationality to her spouse.
Yeah. So this is something that we support. We want that.
Okay.
Yeah. Yeah, I think that's all. If you can.
Okay, thank you very much, Honorable Zede. Now we move to Zambia. Honorable members, even if something passionate comes up, let us allow the member to finish and note it so that we may conclude and give all the countries the opportunity. Zambia, kindly take the floor.
Thank you, Madam SG. I won't take much of the time for this Honorable House. We find that the document itself is good. I think I was going to use the words that the Honorable Member from Tanzania has used, word for word. The only thing that I'll add to what he has said is something on page 55, if you don't mind. Yeah. Page 55, subsection H. all we're asking for not to raise too much trouble is subsection H says, ensure that victims are not discriminated on any grounds or status. We thought that would be maybe the best way to put it. Then page 65. Yeah. Page 65, section 7, subsection A, something similar to it. Reads, discriminate against a victim on grounds of race or grounds, on grounds of status. So we thought we could leave it there. Then whoever wants to include the other words can go ahead and include that. But this is our view as Zambia. Sorry. So we thought that we could do away with the other words that have been in contention and use the word status. So non-discriminatory on the basis of status. Thank you, I submit.
Thank you, Zambia. May we now have Zimbabwe?
Thank you very much, SG. We've met as Zimbabwe, and these are our submissions. The country position is that we are clearly in support of the consultative processes that have gone into the model law on GBV. The country has been part of the consultative process through the Ministry of Justice and other key stakeholders. Our take as a country is that the spirit and letter of the model law-making process is to produce a document from which the country can pick the best practices. As Parliament of Zimbabwe, we have participated in the law-making process of the model law on child marriages and the model law on HIV and AIDS, and they have domesticated some of the provisions of the model laws into our national legislation. In fact, our public consultations on the current Marriage Act, which is before the Senate, were guided by the model law on eradicating child marriage and protecting those already in marriage, which was launched in Zimbabwe in 2016. Model law making has been an integral part of the business of the SADC-PF. Let us hasten to add that participation in adoption of the model law by Zimbabwe does not entail adoption of the full document. Our take is, and has always been, that at the national level, Parliament of Zimbabwe will consider the model law, adopt and domesticate clauses that the country is agreeable with, that are in line with its values, ideals, aspirations, and the national interest. That said, the following observations have been made by the Zimbabwe delegation. On page 31, we request that among the international instruments specifically mentioned in the model law, we include the Convention on the Rights of People with Disabilities, as they are differently impacted by the GBV. That way, their needs will not fall off the radar. To enhance the objectives, on page 54, the model law perhaps should provide for gender mainstreaming in all learning institutions and victim friendly assistance. On page 67, where it is written 3, a woman who is in custody or in a place that is hard to reach shall be entitled to protection from gender-based violence by the state. We are requesting the meeting to put it as any person, or rather any woman or man. This addition is made in the spirit of inclusivity in the gender dimension. On page 71.
Madam Chair, can Zimbabwe just go back to 54? Because, you know, we have to scroll the pages. Yeah, please. And
page 54, the model law perhaps should provide for gender mainstreaming.
Which article? In which article?
Our technical staff will submit.
They'll submit. They've done a write-up.
Okay.
They'll submit.
Okay.
May I also kindly encourage all the other countries to make a write-up and submit to facilitate the drafter at this point.
Can I go on? On page 71, item 4, at the end, separate is, I think that was covered by Lesotho.
Honorable members, kindly let us, you know how our voices get caught. I know it's difficult not to. Okay, let's proceed, Zimbabwe.
We also want to commend the model law for providing mechanisms that offer help to GBV offenders beyond criminal punishment. For example, counseling sessions, rehabilitation, and therapy on page 103 to 104. This will assist in the reintegration of those offenders who may, for lack of better word, repent and contribute positively to society. That is our submission. I thank you.
Thank you, Zimbabwe. We have now come to the end of the submissions at this point, and I believe that these were representatives of the contributions from the member parliaments. I would like at this point I wouldn't want us to rush. I think we should adjourn so that in the morning we're able to consolidate for you and indicate any feedback that would be necessary to chart the way forward of how we would then be able to look at the issue of the 50th Plenary Assembly. I've also gotten a request. I would not want to subject this to a vote, but I was asked why we do not follow what Malawi said, that we need more time and that the model law should be, I don't know for how long, it should be held in abeyance or it shouldn't go to the 50th plenary. You were saying executive committee is only going to plenary now. December 11 is plenary. The plenary assembly is held on the 10, 11, and 12. So EXCO is yeah. So the suggestion, I don't know what, maybe Malawi could clarify that for us so that we settle that issue. Are we proceeding with the model law? Are we requesting to suspend so that we resolve on this matter and administratively we know how to align?
Thank you, Madam SG. That was a proposal from Malawi, but we would also like to hear what other countries would say. We do not want to have a document going to plenary that still has contentious issues. So because we don't want to go through what has happened here during plenary, otherwise we might not have a good meeting at that end. But depending on what other countries will say, there can be a way of going through the document again, present it, or we pend it until the next plenary. that is up to the member countries. Yeah.
The exercise that we're doing is to make input. If there's still suspicion that this document may go unattended to, then I'm not sure how to respond to that. But there's a proposal that I was asked to follow through on what Malawi indicated, Eswatini and then Botswana.
Madam Chair, it was a valid point raised by Malawi, but as we have been following the submissions, I think we have done justice to this document. I don't think there will be any point of meeting again unless Malawi feels he has not adequately consulted. For instance, in Swaziland, I don't think there will be anything to consult. This document has been thoroughly looked into. And I don't know, I would think we've just done justice following your suggestion, the leadership suggestions. But what could be left on that one, Madam Chair? I don't know if Malawi can reconsider. But
okay.
Thank you very much. I would like to agree with Eswatini. When we were making this presentation, it was based on our findings. We didn't hear what other countries were going to say. Now, after every country did the presentation, we're very sure that some of the concerns that we had might have been adopted. So after we adjourn today, for tomorrow, we can be able to see if we are comfortable with everything. Then we can make a decision to say, okay, let's take it to plenary because our concerns have been addressed or not. But our recommendation was based on before everyone did the presentation, Madam SJ.
Okay. Yes, I need your guidance here, honorable members. All member contributions have been taken on board. Seychelles made a contribution, South Africa made a contribution. If we say all, what do we mean? That all member contributions have been taken on board. What liberties does the drafter have or the secretariat have in this particular case? I'm not doing a dialogue with you, Honorable. I just want to be clear, because the role of the secretariat is not to take sides. We serve all members equally, and we have to take your board. That is why you find that earlier on we're saying, why is that words keep coming? No, we have to put what each member state is saying. So that is where we are coming in, just to give clarity to what we are proposing. Botswana?
Thank you, Madam SG. I'm not too sure if I'll be able to help you resolve the predicament. And I think the predicament, in essence, is this: we hold divergent views. And when we say all members' views have been taken on board, some of those views contradict each other. But the practice is that we don't resort to what the majority say. It's clearly going to be difficult to reach a common position, because where countries differ, even with the knowledge that this is not an imposition for you to adopt in your country, they still feel strongly that certain things that they know they will never adopt must be left out nonetheless. And I think it mainly crystallizes around the issues of the rights of sexual minorities. So I really think that taking the paper forward, it's as good as going to get it declared dead on arrival. We may need to do two things: decide if we want to have some convergence around issues of sexual minorities, which I suspect is going to be exceptionally difficult, or agree to save the paper by taking out issues dealing with the rights of sexual minorities as a compromise. I think it's something that, Madam SG, we may need to reflect over tonight, because it's certainly a very good paper and it's addressing an issue that affects all of our countries. It will be sad not to see it go through, because sitting here, I'm concerned about some cultural practices in Botswana. And because I'm too emotionally attached to those cultural practices, I would rather kill or use my votes to frustrate the paper not to pass. So I think let's reflect on whether we should really have the debate on, is there scope for convergence around sexual rights of sexual minorities? If not, in those jurisdictions where there is greater tolerance for the rights of those peoples, are we willing to forgo that component so that we at least save the raw bones of the paper? That's really my view. Thanks.
Thank you. Lesotho?
Thank you, Madam SG. I think really I would echo the sentiments of Botswana. Right now, a lot of work has been done. There's been consultations that took a very long time.
Honourable members, please, behind me and this side, I cannot hear now the contribution. Thank you.
There have been consultations that have been made like for a very long time with different stakeholders. And I'd like to believe all of us who are here would like to see this work come to finality. But it's definitely not a question that with the divergent views, we need to introspect and come to a common ground. And I think as different member parliaments, we really have to determine the areas that we feel we can do without and proceed with the document and allow this to be stage one, at least, of the model law, and incorporate other views at a later stage. As far as Lesotho is concerned, we are willing to get to a common ground with all the other member states. And if there are other sections within the document that seem to compromise the unity, then we will be willing to take the stance that we remove those areas that compromise the document to finality. So I think really it's just for introspection. We've done a lot of work, we've spent a lot of time, and it's just one or two or three areas that really make us look at this document in a different fashion. The submissions that have been made by the different member parliaments is that the document is well presented, well documented, except for those few areas. And really, removal of some of those pertinent areas does not change the shape of the document, because they are still implied, much as they are not explicitly expressed. Thank you.
Thank you, honourable members. We meet tomorrow at 9.
Before you conclude, just a thought for the honourable members. As you go, maybe you should carry with you that there is an alternative, that you use the term marginalized communities instead of sexual orientation. You can use such terms, and the explanatory notes can also lean towards marginalized communities without mentioning their sexual status. You can think about it this night and see whether we can incorporate those words instead of being so explicit. And I agree with Botswana. What she says, that it makes it much easier instead of Lesotho and Botswana, I think they both made the points. It's much easier to come to a common understanding instead of, because of one simple thing, we do away with the rest of a very good document. So just a thought that you can carry with you.
Okay, thank you very much. And also just to be standard, earlier on, there was a request to say what lessons have been learned previously where there is such a conflict. And I'd like to borrow particularly around the issue of sexual minorities, or previously when there was a problem, the ministers agreed each country should go and define who are the key populations. This addresses the issue because if we just say key populations, you will find that in X country, key populations don't include, key populations are children, women, and the others. In another country, you allow them to mention the names of what they want. So as opposed to deviating to a point where we are taking away from what the region has been trying to work around and compromise, we should really align. The other issue I would encourage, please, honorable members, if you have a straight line to your permanent secretary to health or the minister, please consult. It would really be an embarrassment to find that, as usual, this happened. Yeah, let us consult because they have gone to look at each country, go and define who your key populations are. And it is mainly, when we discuss some of these issues, it is not mainly around the influence or the acceptance of certain persons. It is also around how we mitigate and prevent violence in this case. It is also around how we work around meeting our targets around health and many others. So please let us consult. They will give you a word. We'll come here tomorrow. It will not be out of what we think or believe. It will be at least based on the country position as well. I would encourage that to happen because it will help us go a long way. In addition to what has been said already, to see how we move around it. So it is off the table, the fact that we do not take we cannot, a decision has been made anyway that this should be tabled at the 50th Plenary Assembly by the Executive Committee. So that is not an option. But there were members who were asking, because at plenary, that is where you can say, now that it's laid in the House, this is what we are saying. So we still have an opportunity. Tomorrow, I'm not sure if members still want us to share with them the structure of the forum, the issues around the parliament, so that we are all at the same level, the members. So we will integrate that into tomorrow's interventions and see if we can finish at least by midday to allow us to regionally integrate eventually and leave the dollars in South Africa. They've opened up the tourism for us. So with that, honorable members, colleagues, technical staff, let us remain behind, and honorable members, have a good evening.
Thank you very much.
Veluma tuko.
Bye bye, Veluma. See you tomorrow.
See you all tomorrow.